continuing testimony on S45, and we're going to have Gerard, if you could join us at the witness table and identify yourself for the record and proceed with your testimony. Thank you for being here. Thank you very much for taking the time.
Hello, my name is Gerard Borsteveld. Claudine's my attorney, and I guess I'd like to share my story.
Great, thank you.
I'm sure you're not used to doing this. I'm guessing. So just take a deep breath and
I'd like to share my experience with the right to farm law. I farm with my two brothers in Panton, Vermont. We've been in litigation with a neighbor for over 5 years. The current right to farm law does not give much protection to farmers, even if the farm is following all the rules and going above and beyond the requirements. Let me give you an overview of the case. In 2013, a large next-door farm that was owned by a lawyer came up for sale. We purchased the farmsteads, buildings, and 1,500 acres of farmland as it was right next door. The farmstead and about 350 acres sit uphill and across the road from the lakefront portion of the lawyer's farm. In 2014, the neighbor purchased the lakefront portion. Almost immediately after we purchased it, we began improving the farmsteads in the land. We installed 2 manure pits and made other improvements to the facilities. The land was improved by removing overgrown brush, trees, and converting old pastures into fields. We took out hedgerows and combined fields to bring them up to modern farming standards. We worked on surface drainage and installed subsurface drainage tile. All this took years to complete. In the fall of 2015, the new neighbor approached us about wanting to purchase the farmstead and 200 acres of land. We had no intentions of selling it as we were using the facilities. Soon after that, the neighbors, started taking pictures. They spent several years taking pictures and videos of our property and activities. They had taken thousands of pictures and hours of video and drone footage. I think it was in 2019, the neighbor's lawyer sent our lawyer a packet written by an expert that they had hired of what they didn't like, what we were doing with our land and our farming practices. They wanted a meeting with us, which we did. They pretty much told us to farm in the manner that their expert had laid out for us, or they were going to take us to court. They had spelled out how we were to farm our land and have regular biannual inspections by them to see if we were meeting their standards and if we needed to make changes. Were necessary to their recommendations. They had issues with the water running onto their property from ours and some abutting land that's a little further uphill. The water crosses the road through 3 culverts onto their properties into 2 gullies which flow into Lake Champlain. The water has always gone through those same 3 culverts. In late 2021 and early 2022, we went to court. The complaints were water trespass, smell, flies, and traffic. They were able to convince the judge that the subsurface tile system was ruining their property and lives. The judge decided in their favor, due in part to the right to farm law. At trial, we didn't prove to the judge that we were complying with all the rules. From the judges, whatever you call it. Quote, evidence of lack of enforcement of RAPs does not support an inference of compliance, unquote. We had 3 people from the Department of Agriculture testify in court. They could not testify that we were in compliance because we're not expert witnesses. They could only testify that we were not in violation of the rules. We also didn't prove that we didn't significantly change the agricultural activities. Quote, the Forstevels do not use the traditional method of tilling their cropland. This had been the practice used by Dennis Mueller when he managed the farm. Unquote. We used to till the crop fields, but now we inject manure and grow cover crops. This method is much better for the environment. It has also changed the soil, making it healthier and productive. We farm about 2,700 acres, 1,000 acres of grass and alfalfa, and 1,700 acres of corn. We no-till most of our corn and minimal till only when necessary. All the manure is injected in the cornfields and cover crops grown in the off-season on all the corn ground. These are changes we have made over the last 15 to 20 years. They are promoted by the state. We have worked closely with UVM Extension on cropping techniques and soil information. We have a good relationship with the Department of Ag. They have helped with manure pits, leachate systems, and other issues. We get inspected once a year. They do find minor issues or potential issues. We try to correct them quickly. We like to be proactive on regulatory issues. We have been in court several times on this case. The judge is not clear on how we need to comply with their injunction. We hired an engineer to design water quality improvements that were installed last winter. Neither the judge nor the neighbor were satisfied with it. Last fall, we dug up all the tile lines, dug all the outlets up, and plugged all the tile outlets. Now we are scheduled in court again in late April. This case is never going to end. The issue of smell was brought up once in the last 3 years. The fly issue never came up, and they dropped a traffic complaint. The neighbor has way more resources to throw at this case than we do. We have spent hundreds of thousands of dollars on this, and the end is nowhere in sight. Last summer, he told my brother on the side of the road, he's not going to stop till we were out of business. Who should decide what farms can do, the law or neighbors? Our neighbors were hoping to be able to regulate us much in the way the state does, only to their standards. If farmers are doing things correctly, they should have some protection from nuisance and trespass lawsuits. Let the appropriate agencies regulate the farms and hold them accountable for following the law. Even the neighbor's expert witness in the original trial at an unrelated conference stated that if a farm is following all the rules and doing things correctly, they can lose in a court of law.
We take any questions? Any questions? First of all, just thank you very much for that testimony. That is very helpful to understand the impact of this issue on individuals. So, any questions? Go ahead, Ken.
So apologize, I missed most everything, but how long have you been farming?
We took it over from my father in 1998.
So it's been in your family for,
The home farm, but we've been slowly expanding. We're now milking around 1,400 cows. 98, I think we were milking like 350
and your dad started when?
before I was born. We moved here in 1979.
Thank you. So if I heard you correctly, Department of Agriculture is happy with what you're doing. They'll come in, they inspect, they'll make some suggestions to you. You'll go and try to adapt to them. No problems with ag. Only your neighbors are the ones that are upset.
Correct. So,
Traffic, I'm sorry?
yeah, the Department of Ag, we have an annual inspection from the Department of Ag. And then they will spend the day at our place. They walk around the farms, the manure pits, all the buildings. They walk around some of the fields.
And you're injecting more than manure. You said you're not tilling or anything like that, not like the old days, like I
Correct.
used to do.
No, we hire a custom guy. We do spread on surface supply on grass ground, but our corn ground, we inject all the manure.
And
And then we grow cover crops on all the corn ground. And then like in the spring, we'll terminate the cover crop and then we just plant right into it.
So you've upgraded all the processes previous owner, from the previous owner.
Correct. Yep.
So how many acres are we talking about that's, lack of better word, tillable, working land that
Now
you,
we farm, we farm about 2,700 acres, 1,000 acres of grass and alfalfa and 1,700 acres of corn.
traffic complaint, what's that all about?
You would have to ask the neighbors. They were, in the original lawsuit, they had the water, flies, smell, and traffic complaint.
Do you have a lot of traffic that goes by your farm?
No, I think it was traffic that we were causing.
You have a lot of traffic that goes out of your driveways?
I know they had a trail cam set up on their fence at our driveway, taking pictures of all the vehicles going in and out. No. I mean, so we saw a bunch of those and some of them were time stamped. It's like, oh yeah, there's me going in there. Oh, there's me coming out. Oh, there's me going back.
I assume you have a lot of vehicles. You're a farmer and you're taking care of a lot of land, so I think I got my answer.
So what I think is he wanted to buy that 200 acres. To be totally honest with you, we paid $3 million for 1,500 acres in the farm. He paid 3.25 for the lakefront property, which is like 120 acres, 140 acres in a house, a couple houses on there. He offered us $3 million for the 200 acres in the buildings, which is actually a pretty good deal. But we're like, dude, we just bought it. We're just farming, and we had grown our farm to accommodate the purchase, so we're using those buildings. And used buildings are like way cheaper than building new ones. And so we're like, no, $3 million's not enough. So me and my brother and I sat down and figured out the infrastructure that was on that farm, how much it would be to rebuild on our home farm. And then we told him, well, for $7 million, we'll sell it to you. And I think that's what pissed him off. We wouldn't sell him the 200 acres, so his daughter could find. And now we're in court. And I don't think there's any way to get out of court because he's got money. He's just going to keep the ball rolling.
Sounds like you're a pretty proud farmer to be in Vermont. Well, except for this.
I don't know. Yesterday, I was suicidal after looking at the tile outlets, and we're planning on building a barn, and I just don't know what to do. We do a good job farming. We're good people. We work hard. We are right along the lake, and there's some people along the lake that don't like us because they're from over there.
Gotcha. Thank you.
Any other questions?
Yeah,
Yeah, go ahead, Tom.
so your family's owned the farm since '79, you said?
Yes,
How long was it farm before that?
the home farm, or
The original, I guess.
so we farm
Or
on.
the original or the one that you bought, either one or both or.
So we moved here in '79 on Jersey Street, which is like maybe a mile off the lake. This farm is like probably 2.5 miles up the road. It's called Arnold Bay Road, but it's like the road along the lake. That place, they built that barn in 1978. It was a lawyer from New York City. He was a corporate lawyer that had like 200 lawyers working underneath him. I've never met the guy. He died in the late 90s. My brother has, my father has. Real nice guy. Started from scratch. Like made oodles and oodles of money. And this was like his little hobby farm. It used to be a beef farm. I think he started buying property up in that neck of the woods in the mid-60s. And I've heard that like when farms back then in the 60s, 70s, like were looking to get done, they would just go talk to him and he'd buy their farm. Because he was a rich lawyer. And it was like his, nice Vermont farm.
So that was the original farm?
The farm that we bought?
That's the original farm that your family owned?
No, that's not that.
No,
No,
that's the one you.
yes, the one that we have all the litigation with. Yes.
I had another question, but I forgot what it was. Yeah, it's gone.
All right, I thank you very much for, oh, I'm sorry, Angela, go ahead. I didn't see your hand.
So what, this hearing you have in April or
Yep.
yeah, later next month. What is that hearing on? Like, where does your case stand?
So he dug up all the ends of the tile lines and capped them. And I took pictures of every one of them. Lost my phone in one of them, so the first, like. Presented all that to the judge, emailed her or whatever. The judge was a little confused on what was going on. So in April, we have to prove to the judge that that there's not water coming out of the discharge points from the tile drain system. So I don't know how to do that. Just like Claudine said, how do you prove you weren't speeding? Or how do you prove you're not a shoplifter? How do you prove a negative?
How you proving it? Tom, then Ken.
So we're looking at $1,000 a day fine.
If you can't prove that.
Yeah, and that would start middle of November, from middle of November. So we'd be up.
Retroactive to.
Yeah, so we'd be up to like 180 grand.
Jeez. I'm so sorry. This sounds really wild.
Tom, then,
How would I solve it?
Yeah.
Come to my head would do it. That's what I was thinking yesterday.
Don't do that.
Hopefully we can help.
So a tile drainage system, I assume, is collecting water from your property
Yes.
and discharging it, but you had to shut off the discharge point. So where's it going now?
It's not coming out of the discharge points. It's kind of seeping through some of the ground. Some of it's being held in the ground.
Okay. Making the land wetter.
Yep. And it's beautiful ground.
Right.
It's faced towards the lake. I have contacted a developer. I'm glad we have not sold our development rights.
Yeah, yeah. So not being a farmer, and I think I can guess, but I think I know what the answers are. You said you inject manure, you said, and
Yes.
that's to stop runoff, I assume. So the
Yeah, so the manure's in the ground.
right, it's not running off into the ditches and then
Yeah.
into the lake eventually.
Yeah.
And the same with the cover crops, does the same thing.
Keeps the soil in place and you keep, yeah, yep. Which we were not doing like 15, 20 years ago. I mean, things change and evolve. My father used to moldboard everything. Loved it.
Yeah. Thank you.
go ahead, Ken.
So you're saying you also work with UVM with their agricultural too, right?
Yep,
And they love working with you and
yep.
that's a great thing. So I didn't catch him. Maybe we're not supposed to know this, but where is your farm?
In Panton,
Help me.
Near Virgins.
River Thames.
I just looked at it. Very nice.
Okay.
West River Thames.
And this is a family run operation.
Yes, me, two brothers. There's three of us. We got a couple of nephews on the farm.
And other employees too?
Yep.
Operation.
Yeah, we milk, like around 1,400 cows. Ship 2 loads of milk to Agrimark, Cabot a day. Just a modern dairy farm, no different than most other bigger dairy farms.
It's a hell of a lot different than what I had. But thank you.
Anything else for Thank you very much for being here. I really appreciate you.
Thank you for the opportunity.
You hang in there.
So we'll go to Steve Collier now. Thank you. Last witness of the day.
Good afternoon.
Dude,
Thanks so much for having me. It's Steve Collier. I'm with the Agency of Agriculture. So a lot of what I plan to say has been covered, but I still would like to talk about the bill and answer your questions. And I also really would like an opportunity, if it would be helpful to all of you, to come back at any time and talk about these issues more. We've been working on this for at least 4 years, maybe longer, but I've been around the agency for 5 years. And the first time I read this bill, I thought it looked great until I got to the part that matters and recognized that the law is just really poorly done. And so
The existing law.
the existing law, not in the language, the Agency of Agriculture has been working closely on the language that you have in front of you in S45 for years. We fully support the language. We don't think it's perfect because there's no way to be perfect, but we think it's a fair balance. And I'll talk about that a little bit in depth, but I did bring just a copy of, if you want, of the existing law. Because sometimes it's a little bit easier to read the law without the strike throughs. It's very short, fits on one piece of paper with front and back. But if you take a look at that, I'd like to kind of go through what the law says it does and then what it actually does. And then sort of talk about some of the issues that we think are within the current framework. I'd also like to say you're going to hear, I know the advocates, the environmental advocates have been talking about this long enough, and the trial attorneys, I don't think are quite as interested, but I know some of their arguments. I'm not really planning on trying to refute those in advance today, but I would be happy to come back and talk about those. I think one of the critical things they say, though, is don't fix something that's not broke. This law doesn't matter because people don't use it. I just fundamentally disagree with a statement that just because a law does not get a lot of use, that you shouldn't make it effectively available when it is in play. And I will also say that although there are not a lot of nuisance lawsuits against farms, there are a lot of conflicts with farms and their neighbors all the time. And any one of those can quickly evolve into a nuisance or a trespass lawsuit. And that's fine, but not if the law doesn't serve the purposes of showing what should be done. And that's not only true for farmers. I mean, obviously, we have a very clear interest in wanting farmers to know what they can and can't do, but it's also important for every citizen to know what the law says. And this current structure just doesn't accomplish that. So if you look at the law, if you look, when I first read it, reading 5751, first section, the purpose, it's great. It says all the things the legislature said. We care about farming. We care about agriculture. They highlighted that the importance to the economy. They highlighted the importance to agricultural land being an irreplaceable resource, which I'll talk about that a little bit more in a minute. An earlier rendition of you all talked about the importance of agriculture to preserve the landscape and environmental resources. Talked about the importance of agriculture to tourism. Talked about the importance of being able to grow food, to Vermonters being able to be self-sufficient. And you talked about the general benefit to the health and welfare of the state. Those are all right. You hit the nail on the head. I mean, that is, in our opinion, farming really is the backbone of Vermont, but the backbone is breaking. And I'll talk about that in a minute. Agriculture does not have the foothold in the state that it once had. And the reason that's so important is we do need to eat. And while we need to have clean water and we need to protect our environment, humans are part of our environment. And if we only focus on the conservation aspects of creating kind of a conservation museum, then you forget about the fact that we are part of the environment and we need to utilize it, and we need to utilize it responsibly, but we kind of need to have it all. We can't pick and choose between water and food. We need both. We can't pick and choose between nature, landscapes, and agriculture. We need it all. So it's finding that balance, I think, that's so important. And this law, as it's currently written, does not provide that balance. So, I mean, what the legislature also said about in the purpose is it said, and this is really critical, I think, the legislature said farms need to change. And this isn't also in the initial 5751 section. Farms need to change, diversify, and grow. That's all true. But when we get to the actual actionable language of the statutory protection, you'll see that the language does exactly the opposite of promoting those goals. But that's a recognition that agriculture changes over time. In the 1800s, it was all sheep farming. Starting in the early 1900s and late 1800s, early 1900s, it switched to dairy. Now we're losing dairy. Dairy is still very important to Vermont, and it's still the majority of our ag economy. But we've had great success in diversifying and doing a lot more than just dairy in Vermont, which is critically important. But that sort of change and evolution, if we're going to continue to eat and continue to feed ourselves, is critical to Vermont. And one sort of interesting part about this too is devastating as climate change, or if you have a different name for it, the severe weather that we have has been to Vermont, even in recent years. It's probably a reality that Vermont is going to become a lot better food, a lot more amenable to growing food in the future than it is now. If the climate does continue to increase the temperature as is anticipated, then Vermont's going to be a better place to grow food. And because we have water, it's going to be a lot less susceptible to a lot of the other challenges that other states have, especially drought. But there are going to be more disasters, probably. There's going to be more impacts. But the critical piece of all that is we're not going to have the land base. Right now we are losing land really rapidly. And if we don't hang on to the land and actually increase our land, then in the future, when other people in other states are having more and more problems growing food, and we are suddenly a much better place to grow food with a longer growing season, we're not going to be able to do it. So there are many, many factors that go into the importance of preserving agricultural land, but this is one of them. And that's what the legislature said in this legislative findings and purpose. It says the purpose is to protect reasonable agricultural activities. That's all great. But when we talk about, I just want to give you, I assume we don't talk a lot about farming in Vermont, so I just want to give you a little bit of the scope of what's been happening over the last 100 years. I promise it'll be quick. But, 100 years ago, about 80% of land in Vermont was used for farming. And since that time in the 1920s, farm land use rapidly lost it. And it became so rapid that in the 60s, and probably before that, but in the 60s, people were getting really worried about that in Vermont. In the late 60s, after we'd lost about half of our farmland, so we'd gone from about 80% to about 43% of our land in farming, Governor Hoff chaired a commission back in 1968 that talked about the risk of development to farming and the loss of farmland and how it was changing Vermont. And that's what led to Act 250 in 1970, the enactment of that. It was the fear that we are losing farms in Vermont. That was then, okay, and so in 1970, Act 250 comes in, and we're roughly about 40% of our land was in farming at that time. We had about 420,000 people back then. So we had about 50%. Now we have about 50% more people than we had then. We also have 56% less harvested cropland now than we had when Act 250 was passed in 1970. So even though there was this obvious concern about the loss of our ability to grow food and our loss of farms, it already lost 50% as of the 60s. Since that time, since we took those steps, and there's been many other steps besides Act 250 taken to try to preserve farming, we've lost over half of our cropland, and while we've gained 50% of our population. So that's a pretty stark reality when you look at what's left and what was there before. At the moment, only about 9% of our land in Vermont is in harvested cropland. For the first time, farmers in Vermont actually manage more forests than they do cropland. So while there's still a lot of land in farming, most of it is now forested. So and so there's that historical perspective, but it's not just historical, it's also more recent. For one thing, back when Act 250 was passed, there were about 4,000 dairy farms. Now there's 439. 439 is just a little more than 10% than there were then. But the pace of loss is even more pronounced than that, because if you look at the last 5 years, so from January of 2020, so right before the pandemic hit, we had 649 dairy farms in Vermont. We now have 439. So we've lost 32% of our dairy farms in the last 5 years. That's a big number to lose in that short of a period of time. That doesn't mean we've lost all the production. Some farms have grown, some of the land has remained in production, but we've lost a lot of it. Another really concerning statistic is to have farmland be productive, you need farmers. And the average age of farmers in Vermont now is almost 58. So the new generation is not buying in to the 24/7 sort of 7 day a week, 365 day a year mentality that's required to be a good farmer. So it's a real problem that we have a really talented group of farmers in the state right now, but that we're just losing them and they're aging out. I don't know if
So just to be clear, we've lost a lot of farmland. I assume that's all to development. The majority of it's development.
we don't have exact figures on that, but I think most of it is to development. Some of it grows up. Some of the marginal fields stop being used. As soon as they grow up, a lot of them become wetland. You can't touch them anymore. But yeah, I mean, in reality, most ag land is very conducive to development because it's clear.
Yep.
It's often more flat. It's often near resources, other resources. It's often near waterways. So it's very easy to develop it, and there is tremendous pressure. I mean, as Mr. Vorsterveld just said, talking about he could easily sell his land for development. People do that all the time. That's their right. But once land gets developed, it doesn't come back and be productive farmland again. In those statistics, I'm saying over the long haul, I mean, we've been losing a lot of farms recently, but we've also lost in the last 5 year census period. So that's 2017 to 2022. We lost 11% of our harvested cropland. So we're losing it all while farmers continue to deliver. I mean, these losses are serious and it's something we think about every day. But I also want to emphasize that Vermont farmers are still incredibly productive. And we're going to be publishing a study shortly that talks about the impact of dairy. And the reason dairy gets a lot of attention is it's over 70% of the agricultural revenue in the state. And it's also a year-round activity. I mean, all of our activities are important. Our produce, our vegetables, our maple, our honey. I mean, we have so many activities that are really important to the overall agricultural structure. But dairy is probably the only one that's generating income, 365 days a year. And it is where most of Vermont has been targeted. So those losses, when you're talking about industries like Ben and Jerry's and Cabot and DFA, I mean, and the number of jobs that are tied to that, and the cheese industry, the raw milk cheese industry in the state, like there's so much that is tied to ag. And if you go to Glover, or you go to Derby, or you go to any one of the small towns in your communities, you see that ag is still prevalent, but if you've lived in most of your life in the state like I have, you also notice how much is gone. You go hiking on a mountaintop, and a beautiful mountaintop in Vermont now, and you look out at the cleared fields, there's a lot that are no longer there. And you still have Addison County, you still have Franklin County, you still have Orleans County. There's still some areas that are predominantly farmland, but there's a lot that's not. And so that, I think it's just important, from our perspective at least, it's important to keep that in mind when we're thinking about why it matters to protect farms. And in this bill, S45, we really feel like it's quite a modest change to the current law, but it's a really critically important one for farms. And so if I could just kind of go into the deficits, and Claudine, Attorney Safar, she so respectfully used my attorney moniker, which just embarrasses me, but she pointed out a lot of these things. But so you go through the purpose and you go through the definitions. They're good. They make perfect sense. So that's 57, 52 incorporates a lot of definitions. Those definitions actually were updated a couple of years ago. And part of those are now in part of the agriculture agency's chapter in Title 6. So the definitions are pretty inclusive. They don't cover everything. Like somebody asked about on-farm accessory on-farm business activities. Like they don't cover events on farms, or events that aren't directly related to farming. But generally speaking, I feel like farming is well defined. But the problem is with the alleged protection that exists, and that's in 57, 53. The way the whole protection is set up is that the farmer has to build it. Normally I've practiced law a lot of years now, and the standard way that our judicial system works is that if a plaintiff or a prosecutor wants to prove that someone's doing something wrong, the onus of proving that is on them. Like if you're going to sue somebody and prove that they hurt you, you bear that burden of proof. The way that this defense was set up is that the defense has to be proven by the farmer before they're entitled to any defense. So there's zero protection at all from the start. The whole onus of establishing the protection goes on the farmer. And I've tried to think of an analogy that I like to picture things. And so one thing that, and this came to mind just because farmers have been so ravaged by floods recently, but if you picture a big raging river and there's a farm right below it, and the only thing that's separating the raging river from the farm is a dam. And so let's think about this legal protection as the dam. And if that dam holds, then if the farmer's doing everything right, then it will be protected from, and a lawsuit, I think, is akin to, it's a risk, just like a drought or a flood is to a farm. If a farm gets involved in a lawsuit, it can cause a lot of damage, or it can literally wipe them out, depending on the scope of the lawsuit. So I think if I think about this dam being what's protecting the farm from a lawsuit, and no one's saying a farm should be protected from a legitimate lawsuit. What we're saying is that the ground rules should be clear and that they should be protected as much as possible from frivolous lawsuits. But if that dam is there, the way it's built right now, the farmer, so as soon as you file the suit, that's the water starts coming through. Because the problem with litigation, if anyone's ever been involved in it as a party, is once you're in it, you lose. Even if you win at the end of the day, you're losing because it's so expensive. If you've got to hire an attorney, I mean, I don't know exactly what the rates are now, but you're going to pay at least $250 an hour, I think, for an attorney. If higher, maybe higher, I mean, that's maybe $300. It depends. But even if you, for easy math, let's say it's $250 an hour for an attorney. A 40-hour work week for an attorney, that's nothing, right? That's just one work week. That's $10,000. So if you get involved in a suit that lasts 2 or 3 years, which is common for any kind of civil action, you're talking about, as Mr. Vorsterveld said, hundreds of thousands of dollars. So that's like, once the water starts coming through the dam, you're paying, you're losing. Even if you're right, even if you've done everything right, you're still paying that fee. But in this case, the way this is set up, the farmer has to build the dam while they're in the litigation. So in order to have a dam, they actually have to prove all of these things. And they really are, Claudine and talked about these things, but they're really like ambiguous and innocuous protections. We've called them 4 prongs that you see here, and A1, A through D. It's many more than 4 prongs, because you have to conduct yourself in conformity with federal, state, local laws and regulations. That could be 10 different things there easily. What does that mean, federal law? As an example, the federal law protects wetlands. So if a farm violates the Wetlands Protection Act or the Clean Water Act on a farm, and so they have an actual wetland violation on their farm, and their manure smells, does that mean they're not entitled to any nuisance protection, even though the manure smell has nothing whatsoever to do with the wetland protection? I mean, that's just a flawed sort of analysis when you state it this broadly, that you have to comply with every regulation. If you violate a zoning bylaw because you have too many people over on your farm and it has nothing to do with farming, and you have a big party and you don't get a permit, does that mean you're not entitled to nuisance protection for your farming activities? That's just that's when I first read this, I literally said, what does this mean? And how is the farm supposed to go about proving it?
Tom,
What does a farm inspection entitle you if we have to have?
Well, that's a great point. And the farm, there's but I think it's also important to recognize there are 2 different things. So the state regulates farms, and the state regulates farms in many different ways. Our agency regulates farms. The Agency of Natural Resources regulate farms. Other agencies in towns and municipalities regulate farms, depending on what they're doing. This nuisance and trespass is totally independent of that. This is about private land rights, and it's about one neighbor's ability to say, your use of your land is encroaching on my enjoyment and use of mine. So they are different.
Right. My question is just in acknowledging that a farmer's in compliance and met a standard.
Well, yes, and that's what we're asking you all to do, is instead of having this ambiguous standard that puts the farmer, the one is trying to plug up the dam while the water is rushing over by explaining out, by proving their innocence, proving the negative, going to all the effort to prove I'm doing everything right. I mean, that's what they have to do to get any protection under this law. The plaintiff has no burden other than to say, your manure stinks and it bothers me. Like, that's enough for the plaintiff to get started. And then the farmer's like, wait a second, I'm doing all these things. I'm not violating any laws. Even identifying what laws might be at issue is really challenging. And that's what, when we get into S-445 a little bit, what we're suggesting is that instead of individual neighbors and individual courts deciding what farmers can do, we're suggesting that the legislature should set the standards. And if the farm is meeting those standards, then they shouldn't be subject to suit. And that's what's different. Instead of asking the farm to scramble around and prove that they're doing everything right, we think it makes sense for the legislature to say, these are what's required of you farms. And if you're doing this, you're not subject to suit.
But don't we now set water quality standards and fertilization standards, or does somebody do that?
Farms are heavily regulated. Absolutely. And that's what S-45 would do. It would say, so Chapter 215 of Title VI is one of the things you'd have to do to be following good agricultural practices and to have this nuisance protection. Those are very rigorous standards that apply to all farms to ensure things like you don't discharge waste onto your neighbor's property. I mean, that's one of the requirements of the required agricultural practices, is that you're not discharging your waste on your neighbor's property. So if a farm was doing that, then that wouldn't be an automatic protection to a nuisance suit. But right now, there's not even that sort of contours about what it is a farm can do and can't do. And the other piece that the proposed law would do is say you've got to follow the pesticide rule. So a lot of people are understandably concerned. They maybe don't mind if their neighbors use pesticides. They maybe do, but they don't want the pesticides on their lands. That's legitimate, but there's a whole, there's a 60-page plus rule that defines how pesticides have to be appropriately used in the state. And if they're not used appropriately, they're subject to enforcement by our agency. But under S-45, they would also be subject to a private civil action if someone wasn't using pesticides appropriately. That could constitute a nuisance or potentially even a trespass. That's a little bit. So that's the idea, is instead of throwing this out there for every judge or jury or farmer or neighbor to try to figure out, it's to set the rules so that people know what they do. And when you don't know what the rules are, it's really hard to hold people to that standard. I mean, right now, even if you want to do your best, if you go look, say if you're a farmer or a neighbor and you say, okay, what are the ground rules? And you go look at this statute, no lawyer can give you good advice about what this really means. So if you can't be given good advice about what it really means, then it's awfully hard to comply with what those are. And that's the same thing with good agricultural practices, which you've talked about. That's very subjective, probably requires an expert to prove what that is, which is more, and again, that would be right now.
That'd be on the plan.
That would be right now in the current law, that'd be on the farmer to prove that they're doing it.
Right now, but if it's now, then it would be on the plaintiff, who's the person with the problem.
And that to me is the critical shift about all of this, because if I don't know how many of you are lawyers or know how it works when you get into court, but if you're sued, then a judge can't decide a disputed factual issue. So if the farmer and the neighbor are arguing about a fact, and the farmer's saying, well, I spread my manure appropriately, and the neighbor's saying, no, you don't. That's not something that the judge can do on the papers that are submitted before them. There has to be a trial, because you have to be able to judge credibility. There's nothing wrong with a trial, but the problem with a trial is that if you have to wait until trial, that means it's years now, because the period of discovery takes a long time. There's a lot of work that goes into that, exchanging paperwork, hiring experts, taking depositions. That all takes a lot of time and a lot of money. And then, so only at trial can that fact be decided. So my biggest objection with the current law is it sets up a tremendous amount of factual issues. So you can never resolve a dispute early if the parties don't want to. If the parties are going to resolve this, they're going to have to go to court, and that's just incredibly expensive. If you instead, and especially because the farmer's the one with the burden to prove it, if you instead put the burden on the plaintiff where it normally belongs, then the plaintiff has to say not just that I don't like the smell of your manure, but they have to say, I don't like the smell of your manure, and by the way, you're not storing it correctly because you violated this part of the water, the water quality rules, you violated something of that, or you've done something you haven't kept it under setback for my property. They're going to have to show that the farmer's doing something wrong with that manure, or they're not following proper and customary accepted practices. They can't just say the manure stinks. They have to say it stinks and here's why. And when you do that, you narrow the whole scope of the issues at dispute. If you just say the farmer, you got to show you're doing everything under the sun right, then that just opens up everything. But if the onus is on the plaintiff to say, not only does your manure stink, but here's what you're doing wrong, it narrows the issues. And so then, maybe the neighbor has a good point and the farmer can actually say, okay, I'll fix that. Or maybe not. But if the plaintiff doesn't have any evidence that the farmer is doing something wrong, then the farmer can file a motion for summary judgment with the evidence showing he's doing it right or she's doing it right. And the court can actually potentially get rid of the case pretty quickly instead of going through years of litigation. So it's never easy to get out of a lawsuit. It takes some time. But if you define, sorry, go ahead.
Angela has a question.
Well, along the lines of what you're talking about right now, looking at the bill on page 3, lines 6 through 8, do you have any concerns about the the language that says practices conducted in a manner consistent with proper and accepted customs and standards, without further defining who set those standards?
Yes, I do have concerns, but I also view it as kind of maybe a necessary compromise. And the reason is the things that are listed above. So the requirements of Chapter 215, that's the water quality rules that my agency administers. And then you have the pesticide rules below that. Like those are clearly defined things that a plaintiff can show whether they're violating, but can try to show whether a farm's violating those or not. They don't cover everything. So those rules are not the whole universe of things that can cause a nuisance, like noise, as an example. So using a sound cannon could be an example. So some farmers out in, 300-acre farm in the middle of nowhere, and they've got because bears will eat your whole cornfield sometimes. So if you don't protect your field from eating crows, and other birds can also eat the corn, they might have a sound cannon so that goes off periodically, and it's hopefully driving off the bears or the birds. That's not regulated specifically by us. It's something that's protected. It's an agricultural practice that farmers are allowed to do, but there's no specific regulation saying what exactly you have to do if you're using a sound cannon. So I can envision a situation where you're in a suburban neighborhood with 10 blueberry bushes and you've got your sound cannon going off and people are working from home. That maybe is a problem. So I think that the idea of that language from my perspective was you can't cover everything under the rules that are cited. So you need to have some kind of fallback situation so that if a farm is being completely unreasonable and it's not doing something in accordance with accepted standards, then a court has the opportunity and a plaintiff has an opportunity to be able to bring that action. So I do think it has some of the vagueness concerns that the good agricultural practices do, but I think it's better defined because it says, proper and accepted customs by similar operators in the state. And I think there has to be probably needs to be some kind of safety valve, at least in Vermont, the way that we try to balance interests. In Oregon, they would say, "What are you kidding me?" So,
Well, I agree with Oregon, that it sort of puts it in the plaintiff's lap a little bit more.
yeah, no, and that's that's a policy question, where you draw that line, and S-45 does put it in the plaintiff's lap. But when you talk about a proper accepted customs and standards, that begs the question of, do you need an expert? What's the similar operators? How do you get those facts? And so, but my hope is that when it comes in, a lot of the issues relate to water or to manure, to smell, a lot of the things that are covered by water quality or pesticides. So I think a court reading this would understand that if it fell in those rubrics, those are the rules. But if it's outside of that, if it's not specifically regulated, but it's something a farm is doing that, is arguably causing a nuisance, then you've got to have some sort of touchstone to what's allowed and what's not. And this may not, you could define it. I don't know how you could define it particularly well to encompass every situation.
So is it fair to say that there isn't really one or two entities that we could name, the Agency of Agriculture, even may not cover every single eventuality, and so you wouldn't want to specify whose customs and standards we're telling the courts to look to, because it might not be covered.
I don't think they exist as it is. You know, farms have, I mean, sorry, municipalities have police powers to regulate a lot of things. Somebody asked a question about public nuisance before. That's different than a private nuisance. So that, you know, again, this is just a landowner's ability to bring a common law claim. And one thing that's really important about that, these nuisance and trespass claims are old. They come from the crown. They come from common law in England when nothing was regulated. Okay, so you could bring a common law claim, but you didn't have the government was not on your farm or on your plot of land telling you how to plant your field. Now, you know, we have really extensive regulations, and they're all, you know, well designed for good purposes to protect water quality or to protect other people's property. But there's a litany of regulations now that apply. So using the common law nuisance and trespass framework without acknowledging that farms are much more heavily regulated than they used to be, and especially without aligning them, I think just sets up a situation that's not effective for farmers and puts them at risk. And that's the real problem is, you know, most neighbors are well-intentioned and most neighbors will try to work out solutions, but some neighbors are not. Some neighbors just want what they want, and some people have a lot of resources, and it's not of any inconvenience whatsoever to them to bring a lawsuit. And when you're involved in litigation, if you don't have resources, you don't stand a chance in private civil litigation. So I just, you know, trying to make it clear, like farmers, if you're doing things right, as the state requires you to do, then you should deserve some protection. And this protection isn't perfect for those reasons we're talking about, but it's some protection that if a farm is doing things right, they ought to be able to get into the court and say, look, you know, first of all, the plaintiff bears the burden, but even if the plaintiff suggests that these things are wrong, the farmer should have a reasonable way to counter that by showing what they do themselves. But I don't think the agency, if noise, as for example, we don't specifically have regulations for decibels or, you know, all those things that could account for when we thought about it, but it's it's creating another batch of regulations that will never be perfect, and we haven't found the need. But there are disputes that arise over noise, for sure.
So you mentioned earlier that we're going to be hearing from, you're pretty sure we're going to be hearing from some people that have the attitude or the opinion, I guess, if it ain't broke,
Yeah.
don't fix it. So I've been around here long enough that I was here when we passed some of these laws. I mean, if we took that attitude when we were talking about buffers, you know, what's the difference? We took that attitude when we're talking about drainage, you know, building drainage systems or the runoff and that type of thing. And then, I mean, we're talking about, you know, things that I believe farmers have done on their own, self-regulated, I guess, with injecting and cover crops. And I'm going to guess those aren't state regulations. Maybe the cover crops are, but the injection, I'm going to assume, isn't.
No, it's not, but it can be depending on the specific situation on their farm. So there's a formula about sediment runoff.
Right.
And so sometimes you may have to do extra processes that are more protective than is required if you can't meet that. But no, in general, it's not required. It's something that we definitely encourage, and a lot of farmers have adopted. You're right. I mean, that's the wonderful thing about Vermont farmers, in our opinions, they keep rising to the occasion. You know, a few of them come kicking and screaming with good reason because it's expensive.
Right.
They do keep meeting the new thresholds.
So kind of where I'm going with this, and I'm going back to if it ain't broke, don't fix it thing, is that I don't know anything about farming, but I do have some common sense. I like to think I do. And right now, if the laws of the state of Vermont are driving a farmer such as Gerard to the level of anguish that he's going through, it's broke. It's just plain broke. And, you know, and I can't believe he's the only one. You know, maybe not everybody's to the same level. Maybe there's somebody, you know, that are dealing with even more anguish. But I don't know if it's a question for you or maybe Gerard or Claudine. I'm just wondering if you know others in the industry that are going through basically the same thing, that are at their wits' end. There's got to be somebody else. And if it's getting to that level where, you know, not to bring it up, but with Gerard thinking about suicide over this, the law is freaking broke. And it's time to do something about it. And like you said, this has been around for 4 years now. Well, you know what? It's time to change the law.
Well, on that front, we were really heartened that the Senate voted it out so overwhelmingly. I mean, 25-5, that's impressive. And farmers are heartened by it too. I mean, we talk to farmers and farmer groups all the time, and they're really encouraged. It doesn't always feel like farming gets a lot of attention in this building, and it's not ill-intentioned. I mean, the ag committees work very hard on farming, and it's not that I don't think any farmer thinks that people in general don't care, but there's a lot of other attentions that get a lot more. I mean, a lot of other issues that get a lot more of attention, but sometimes very understandably. Homelessness, you know, hunger. There are some very big issues that we're tackling every day, but then not everyone recognizes that it's not just walking into the grocery store to get your food. I mean, farmers are actually doing the hard work to grow our food. And without them, you know, we all need farming. And the only thing you can do is displace it. You know, you can keep displacing it and put the environmental costs somewhere else. You can say, you know, we're not going to do it in Vermont because we'd rather have, you know, as much conservation as possible. But that just means we displace our food, the environmental cost of our food to some other place. And we also then have to transport the food, which we already do a lot of. But, you know, there's a lot of groups that are working really hard in this area to try to get New England's production of food up. Where there's a goal to strive to get New England, so it's more of a regional approach, but get 30% of our food production in New England from New England. We're a little over 20% now, roughly, of our food production comes from the region. And Vermont and Maine are really the key states to do that. We're the only ones really with a land base currently with a land base to sort of keep that production. But that's, you know, there's always the balancing of the factors. But when you talk about Mr. Vorsterveld and that experience, I mean, you're going to hear horror stories about the water, just, you know, which I'm not, we go to Mr. Vorsterveld's farms every year, as he said. We found some minor things, but they're progressive farmers. You know, they do take care of their property. They do a good job farming. The thing that really gets to me about that whole case is the judge said manure can't stink. So, I mean, they literally said they enjoyed the smell of manure because it was apparently gathering on the property. Well, yeah, manure smells, but you know what? The state of Vermont tells farms how to manage their manure, and they made it smell more. We, the state of Vermont, tell farmers, you can't spread your manure in the winter because you know what? If you do that, it might slide off the snow and the frozen ground into the river. So we're not going to do that. So you know what you have to do? You have to have storage for up to 6 months. For your big farm, medium and large farms have to be able to have the capacity to store their manure for 180 days. Well, guess what? When you do that, manure is a little different to spread. You have to treat it differently. You have to agitate it so that you can spread it, and it's going to stink more. And so, you know, but that's a requirement that we impose on farmers. So then that's just one of many. You know, there's also many things about how they spread it and how they're able to do that. So we have this whole regimen about things, including a nutrient management plan, which farmers have to make sure that they're not over applying nutrients in different fields because if the soil becomes saturated with nutrients, and there's a higher risk of runoff. So we have this whole labyrinth of things that we require farms to do. But then a judge in Vermont says, you know what, farm, your manure stinks. There's no cure to that. I mean, the judge was talking about covering the manure pit. I mean, that creates a potential blast hazard, as I understand it. And that's even if you can afford to do it. So like that just sort of threatens the fundamental ability to farm. I mean, there are some unpleasant to some people, you know, impacts of farming. You know, when you're sugaring and there's round the clock trucks and you live right next to a sugar house because you got to boil when you got to boil, you know, that's probably be unpleasant, but most people recognize that's for a month or so of the year. And you know what? Maple's really important and actually love living next to a farm instead of a development. So, you know, there's those cost benefits. But yes, I mean, if courts were going to enjoin the smell of manure, then you can't be a farm in Vermont. Some farms.
You good? Yeah, I'm good. Thank you.
I'm gonna get a little into the wording here for just a moment.
Yes, sure.
And I think to understand Angela's questioning, so I'm just repeat it. So required agricultural practices and then like everything under chapter what,
215.
215 under 6 VSA. Like there's like lots of stuff in there, but it doesn't cover everything.
Correct.
Okay, so then I'm just looking at this at 57, 53, and it looks like if I understand in 2015, for 2015, it had accepted agricultural practices as the language, and then it was amended, struck accepted, put in required. And so now we're putting back in the accepted agricultural practices, we're adding generally in front of it, and then we're baking in the required agricultural practices into the definition of the generally accepted.
That's a very understandable point, but it unfolded a little differently. So
Okay, thank you. To clarify for me, I'm sure I
So
understand it.
before there were required agricultural practices, which is the current rule that farmers have to comply with. And it was most recently amended after Act 64, which is considered the Clean Water Act in Vermont. So the standards became much rigorous. And one of the things that the legislature said to do is these are no longer acceptable or optional agricultural practices, they're required. So that's just a change. For many years, I think starting in the late 80s, maybe, there were accepted ag practices that farmers were supposed to follow. But the regulations have just continued to tighten it. So that's just a name change. It's also a substantive change because those rules have become much stricter, but it's not a reorienting of that in this bill.
And there isn't any concern that by sort of, I guess I'm just thinking about, because they kept in, the legislator in 2015 kept in the good agricultural practices and then just had required agricultural practices, got rid of the accepted agricultural practices. And so we wouldn't have any language for good agricultural practices. We would just have accepted agriculture, generally acceptable agricultural practices. There's no like concern there that generally acceptable agricultural practices couldn't be sort of like inferred to mean accepted by an entity as opposed to just community.
I don't think so, because the way, I mean, as
Based on C.
because on page 4, line 9, generally accepted practices is defined. But if it wasn't defined, I'd be concerned about it. But it's defined to mean all the water quality requirements, the pesticide requirements, and then practices conducted in a manner consistent with proper and accepted customs and standards. So that it is defined. That subsection C has that wiggle room that we discussed, that, you know, is not perfect, but maybe necessary to encompass the things that aren't covered in subsection A and B. But no, I mean, I do think if you're meeting the water quality requirements, pesticide requirements, and you are doing things in accordance with typical standards, then you should be okay. You still have to prove that, or the plaintiff has to prove you're not, but yeah.
And then I think Angela asked this too, but the Michigan language that where it's having the a commission of agriculture basically define and then review acceptable general whatever the languages they're using
So if you mention Michigan
practices,
during the tournament, I'm going to have a go blue.
Oh, fair.
Especially when they just made the Sweet 16. But no, so no, I mean, we don't. I think honestly people want that. Farmers want that for us to be the sort of determinant of what it is.
Yeah.
It's not our rule to go to the court and tell them what the law means. Our role, sorry. We do regulate, and when we're doing the regulations, we determine what we require to be fixed and whether or not we think there's a penalty in a violation. But we don't have any independent, like, statutory standing to go into a court and say, this is what the law means. You could give us that, but
You don't want it.
I don't know that it would be, I don't know that it would make anything more complicated. If you gave us the power to decide nuisance claims, I guess maybe that would, but I don't know that we would need people. And it is a property law claim that really probably should be decided by the courts and not by the Agency of Agriculture.
Yeah. Okay.
On that topic of the courts, I'm just thinking that I really hope this bill moves forward, and if it were to not, and certainly even if it does, is it fair to say that there might be a need in the judiciary for like a primer on farming? I mean, it sounds absurd some of what you've described, that a judge could say, manure is stinky, take care of it. And perpetuate a lawsuit like this that we just heard.
Agreed. I mean, I think the reality is that through evidence, you can prove that, but a lot of that depends. As an example, and I think maybe Claudia mentioned this, the Agency of Agriculture can go in and tell a court what it's seen on a farm. But the Agency of Agriculture is not on a farm every day and can't tell you what's happened on that farm every day. So we can go in and say, this is what we found. We haven't found a violation. We have found a violation, but there's always going to be more evidence than what we can provide. And we don't provide expert testimony. The state in general doesn't provide expert testimony because then everybody would want us to be an expert. And we're not. The state really, our opinion, shouldn't really be in the business of picking who to, whether to represent a plaintiff or a defendant in a private civil action. What we should be available to do is to provide the facts as we know them. And we do that. But we don't come in and say, in our opinion, that everything is right. A, we don't have all the information to be able to make that judgment. And B, we're not picking sides in lawsuits. We're telling what we know. So maybe.
Is there a blind spot though, maybe?
Yeah, I think if anyone who's been involved in civil litigation, there's always blind spots. And on some level, it's up to the parties to educate the court, but it's expensive and cumbersome. And yes, and we would be absolutely available to go in to a court as witnesses and explain what we do under the required agricultural practices. And we could explain what we think, the required agricultural practices mean. So we can help educate the court. Some also courts have a lot of discretion in what they'll hear and what they won't hear. And sometimes that can be pretty limited.
I guess I'm thinking about some of the other bills that we've passed here, some specifically dealing with domestic violence. And when we introduced the notion of coercive for controlling behavior, there was an acknowledgement that there would be judicial training required to understand what that means, what that encompasses, what the intent of the bill. And so I'm thinking along those lines of judicial training.
Oh, that's interesting.
Having to do with farming and farming practices and.
Yeah, that's interesting.
What's not.
I think that's a great idea. Whether or not it would be, I think the judiciary would have to weigh in a little bit on that.
Absolutely. I wanted to check with you to see if you think that there might be.
Yeah.
And it's not a decision for us to make, I understand, but just in hearing the stories, it seems like it's
interesting. And again, fortunately there aren't a lot of nuisance suits, but I don't agree that that's an important reason not to change a bad law, but they're not constantly in court, but there are regular threats of going to court. So, but I hadn't thought of that. And that's, we do educate towns a lot on farming and on accessory on farm businesses. And we do have a statutory role to educate, but they can still not listen to us if they want.
So I'm sure we probably have additional questions, but I know some folks have to get to a 4:30 meeting. We're going to have you back anyway after we hear the next witnesses, so you can have some possible rebuttal.
That'd be great.
As well. So, but that will, if we have some time on Friday, otherwise next week, we have time.
Whenever you'd like, yeah.
So yeah, I appreciate it. So tomorrow morning at 9, we're going to hear from a couple witnesses on at least one witness on recidivism definitions. We're going to continue to try to find something to put in the miscellaneous bill. So please be here at 9 o'clock for that. And then we're going to continue testimony on this.